document is LM, your member of parliament, your chairman, LC5, your president, whatever the case may be, to challenge the validity of someone's election. Okay, that's the presumption. If by law you get to represent principle in challenging when is the petitioner. Okay, so the presumption is at this time, you know how to vehemently deal with election petitions. You differentiate between non-compliance with the electoral laws, commitment of electoral offences, validity of nomination, and then the kind of prayers. Okay, that is the presumption. So, in that same spirit, today we are dealing with workshop 2. Okay, workshop 2 requires us to appreciate what we call constitutional petitions. And then it also requires us to appreciate judicial review and then enforcement of human rights. The biggest challenge you have is differentiating what facts require judicial review, what facts require constitutional interpretation, and then what facts require enforcement of human rights. Okay? These have a common proceeding. Okay? A common term known as specialized proceeding. So you ask yourself, these are one of the simplest matters. Okay? Why? The reason why they are called specialized proceedings, the way they are handled is totally different. They are dealt with expeditiously, not today. This is the matter which you get, that next month will be fully settled. Yes, enforcement of and torture. Okay. Remember those facts. That when you look at those election petitions, they are dealt expeditious. Okay, reason that's why they are called specialized proceedings. Their time zones are totally different. Okay, around the so-called share requirement. These are specialized. Okay. Okay. So okay, so let's get the constitution. Okay, everything we are looking at starts with the constitution. Yes. Mm.
First way is misspelling of the name. This person is called the document is called the name. There is no other, meaning that is judicial misspelling. If it's called another, then there is a judicial missing letters in that name. Two. Sorry, someone problem. I use I know Leonard, but when I'm making it, I use Leonard. That's Leonard. Now,
Once you add another name, you become another person. There is a difference in what we call arrangement of names and misspelling. There is a case that follows that position, that a mere discrepancy in spelling does not change someone's identity, and that is curable. And a mere misarrangement of names is also curable. But an addition, an adoption or dotting of a name is only curable by a digital. So that means your client adopted a third name. So he had to go for a digital, which he didn't do. So that means, yeah, it's a digital. Okay. So as a result of that, they are two different persons, one in the voters register and one on the nomination. Okay. I will avail you with the same. Okay. Can look at what that national case. So now let's start with the judicial review. Let's first just argue about judicial review. What do you know about judicial review? In the first place, before we say that, let's read the law. What do you know about judicial review? And it's likely to be your third number, your second number at the end. Yes? What's the difference between judicial review and review? What's the difference between judicial review and review? Okay, let's do the do. Someone with the constitution, help me. We are reading laws relating to judicial review, not so? Who is abolish? Abolish. Okay, so let's go. When we are dealing with judicial review, we look at the Constitution and which other law? Yes? We have what we call the judicial review rules. So when you are dealing with judicial review, these are the things to first ask yourself. Okay? One, whether the matter is subject to judicial review. Because we have circumstances where on the face of it, you may think that judicial review is applicable, yet it is not applicable. So the starting point is you to understand under what circumstances can a judicial review be applied. Okay. Then after, ask yourself, which court has jurisdictions to entertain judicial review matters? Then, what remedies do we seek in judicial review? Do you understand what we call statutory, an order of mandamus, prohibition? Okay. And what? And what? Habeas corpus. Councils of saying the habeas corpus in judicial review. Okay. So you get it. Okay. Then ask yourself, what is the mode of application? Is it by chamber summons, originating summons? Is it by petition? Is it by declaration? Whatever the case may be. Okay. So now, what laws do we address? When you look at Article 42, it is very emphatic that every person before any administrative official or body has a right to be treated justly and fairly. Now, what if they ask you, that's what's the cause of action in judicial review? What's the cause of action in judicial review? Okay, so now, what are the elements of judicial of a cause of action? It has a right, the right is violated, and it's violated by. Now, what right do people enjoy to go for judicial review? Yes, under which locus? Article 42. But in 42, may I see a right to be treated just and fair. So what does this mean? That the cause of action, okay, is unfair treatment. Okay, why? This person under Article 42 enjoys a right to be treated, justly and fairly. So you should appreciate that this person appeared before an administrative body. Okay? And this person was not given a just and fair hearing. Okay? Then let's go to the judicial review rules. How do I access it? Okay. Now, we've said that our first issue is whether the matter can be subjected to judicial review. Okay. 14. Okay. So when you go to the judicial review rules, Okay. First, go to rule 3 before you do anything, so that you understand whether the facts before you qualify to go for judicial. The reason why you people found it hard to ascertain which set of facts for judicial review. Okay, you have a set of facts that has two in one. It has judicial review and constitutional interpretation, one part. But people were neglecting some parts. This is constitutional interpretation only, or it is judicial. That is the problem. So now let's go. It says an order for application, an order of mandamus, prohibition, statutory, an injunction under that. Okay. Rule 3, cases appropriate for judicial review. Now, the first thing you need to appreciate is that one, for you to go for judicial review, the decision must have been passed by a quasi-judicial body. Literally, it should be an administrative, not a court, not courts of judicature. Okay? Not courts of judicature. It is supposed to be passed by a quasi-judicial body. Sometimes it is referred to as an administrative body. Today they can give you KCCA. The following year they give you Makerere University. Then they give you the Law Development Center. They give you the Islamic University in Uganda. They are administrative units. Those units are quasi-judicial bodies. So whatever decision they make, okay, there is a judicial review matter that I enjoyed most. It was for Kawempe Mosley. Okay? I've heard of that case. These guys were dismissed from school towards UNEB. They are represented by IK, Council Isaac Semakade. And the guys were reinstated, judicial review, that the school reached the decision to terminate them without following the due procedure. Okay, so when you read, yes, is it a quasi-judicial body? Yes. The difference is the decisions are passed by the minister in his personal capacity. It does not sit as custodian board. That's the difference. But where the decision, because you see, the diversity committee just advises the minister. We give that one, we do this. But they don't sit as a board, you get it? But here, matters that go for judicial review, where you sit as a board, okay? If you say that to pass a decision, the board should be composed of 4 people, where one is not among, that means the body did not constitute the panel. When you guys were appearing for orals, those panels, we can use those examples. Those were quasi-judicial bodies. The decision they were passing was binding on you, not so? So as a result of that, that's why when the number of PAs on the panel were not sufficient, they could pause. Why? You could appeal against that mark, that the panel was not constituted. You get it? So council, get the difference. So now, when you are dealing with the judicial review, the first thing you need to appreciate that the decision should have been passed by a quasi-judicial body, stroke administrative entity. Okay, that's the starting point. But the question is, you understand what amounts to an administrative body? That is the Was ever the case of John Jet Muevas? Yes. You've ever heard of it? How do they define an administrative body? Okay, so when you get time, read that case. Okay, it is John Jet Muevaze versus Makerere University. It is on judicial review. To Muevaze. Okay, it lays down the grounds you base on to go for judicial review. What the challenge is, when you read this, the regulations and the constitution, they don't give you circumstances under which you go for judicial. They are not laid out, but they are in case law. But the case law explains Article 42. That's where we get the grounds. Because in Article 42, every person has a right to be treated justly and fairly. So ask yourself, if one appears before a judicial body, under what circumstances will this person be treated unjustly and unfairly? Okay, so the first one, okay, is where this person is not given a right to a fair hearing. So ask yourself, what amounts to a fair hearing? This is a case-to-case basis. Okay, it's a case-to-case basis where the law sets the procedure of reaching a particular decision. So that means where there is an irregularity in the procedure of reaching the conclusion, it becomes unfair. Okay, how would you tell that there is an irregularity? If the law says that in administrative hearings, the panel should be constituted by 8. If it is less than 8, that is an irregularity. Okay. Then 2, where the law says that someone should be accorded sufficient time, okay, to prepare his or her defense. Where you are not given sufficient time, is that a fair hearing? Okay. So these grounds, they are not static. Unlike the petitions you've been dealing with, these ones, they require that touch of the case now. Okay. Okay. So the case is here. Okay. When you read the case of it is when you have another case here of okay, so when you read the case of John Jet Muevaze, there is a case here where it was quoted, okay, and court held that judicial review is concerned not with the decision, but the decision-making process. It involves an assessment of the manner in which the decision was made. That's what we call the procedural irregularities. So when you are reading, okay, so when you are reading your facts, the facts will first tell you the procedure of reaching a decision. Then at the end, this person will appear before this entity, okay? And again, the procedure will not be followed. So there is no static ground for judicial review. Don't expect you read these rules and get the grounds. Read the article and interpret it. Once you understand Article 42, you're done. Because that's where the irregularities emanate from. Simple as that. Okay? But take time and read that gentleman's case very well.
Article 42 at the bottom of mine. What happens if a person judgment has been reached between that expire and guest that I'm supposed to be, let's say I've been laid off to work for my retirement or unfair to reach a consent judgment, and among the agreement I need to be given my retirement fee. But among the consent judgment that is not then
I know very well. Okay, so the matter for determination in that in the facts you're stating, whether the issue was whether they can consent in an application for judicial review. They don't consent in a judicial review. Why? In all human rights enforcement matters, they don't enter consents. They are determined on merit. So that was the gist of what you're trying to ask. Okay, so are we together? So the challenge you have, people are waiting to read these rules to get to the grounds. The grounds are not there. Even if you read the rules from A up to Z, you remain in the way you are. Okay? So the reason why you got challenges on deciding whether it was judicial review or not, people didn't understand the grounds for judicial review. They read the act and they remained in the way. All this they teach applicability of the law. And we have types of laws. We have what we call court-made laws or judge-made laws. Those are decisions of courts. But for you read the act, you left the decisions of court. Okay, that's why it was a bit difficult. Then our next question was, which courts? Can you go for judicial review? The magistrate's court? Why? When you look at Article 42, still, it says that it is still emphatic, and it says that and shall have a right to apply to court of law in respect of any administrative decision taken against him or her. So what does this mean? The Constitution has given you a right to go to court for judicial review, but it has not told you which courts. So what you do, you come to what we call the judicature judicial review rules. Okay. So now, which court has the jurisdictions? Yes. Why do you congratulate the High Court? From where? Yes. From where? Yes. He said. Yes. Yes. How do you get to that point? that they are handled by the High Court only. Yes? Yes, it's only the High Court. How? Is it by osmosis? Yes? Is it by osmosis? Yes?
Answer.
Yes?
I think we look at the remedies we are looking for, because now certain remedies, they are very specific who grants them.
Who
Like
has the Judicature Act?
yeah, the Judicature Act.
Who has the Judicature Act?
Section 36.
I don't think it's here. The Judicature Act.
Councillor Rashid.
Yes?
Councillor Rashid.
Yes, yes.
The provision of the forum of the court is given under the definition of judicial review.
Yes, but we start with the Judicature Act, the application of the law. Okay?
Section 36
When
of the
you read
Judicature Act.
Section 36, it provides that the remedies you are seeking for in a judicial review are only granted by what? By the High Court. That's where you start from to try and trace the jurisdiction. 36 of the Judicature Act. Then after that, you come to the Judicature Judicial Review Rules. Okay? They define judicial review. Which rule defines judicial review? Now what should we take? We take 3, we take 2. But the way you take them, what is watching you closely? Closely. I'm telling you. Okay? I'm telling you, in our year, our number 1 was judicial review. But I told one of my colleagues at council, my first issue was whether Rashid has a cause of action. Yeah? Judicial review. You think about the cause of action. Yes, very hard. But my marks, when I gave the cause of action and its elements, I was like, I thought in judicial review we don't have a cause of action. That's why I review. Okay, so now let's go. Let's define judicial review. And also, why are we going to this? We are looking for High Court. So that you come to the conclusion that the forum is the High Court only. Because you can't, when they ask you, don't just come to the conclusion that it's High Court. They tell us, I think, they'll tell you, counsel. Lawyers don't think. The law is there. We don't think. We think better when we see man. Huh? Yes. Okay. Hey, am I lying? Okay. So now, when you look at Rule 2 of the Judicature Judicial Review Rules Amendment, says that judicial review means the process by which the High Court, you underline that, only sufficient. Okay. It is Rule 2 of the Judicature Judicial Review Rules. When you see, when you are reading the act, always ensure that don't rush. Okay. Don't rush. Okay. Okay, it has an amendment. Okay, it says Because you see these rules, when you're reading the act, not that everything you want, you have to read the entire act from A up to Z. No, we are looking for the forum. When you say it's the process by which the High Court, that is enough. Only that is sufficient. Okay. So now we've come to the conclusion that the forum is what? The forum is High Court. Okay. That the forum is High Court, not so. Now the question is, who applies for judicial review? Can anyone apply for judicial review? Yes. Who can apply for judicial review? When you look at the amendment, okay, you look at the amendment, there is what we call an insertion, okay? An insertion. Rule 3 says that a person who has a direct or sufficient interest in the matter may apply for judicial review. What does this mean? Okay. For you to apply for judicial review, you should be directly affected when the decision affected you as the person. Okay. Or you should be having sufficient interest in the matter. So the question is, if the decision is passed against me, okay, can Mastula wake up and apply for judicial review? Why? I am the one who is directly affected. Can she, who is not a party to the decision, can she apply for judicial review? Yes? Can she apply for judicial review? Which interest counts? Sufficient. So the question is, what amounts to sufficient? It's a case-to-case basis. So you can't tell. So if she has sufficient interest in this matter, she can also apply. Okay. That's the challenge. The law has not defined the same. Okay. So now, we presume you know what is judicial review, you know where to go, you know that yes, my client can apply for judicial. Now the question is, how do I apply for judicial review? How do you apply for judicial review? Which law? You go to rule 6 of the principal rules, which says that mode of applying for judicial review. Okay. Rules that are not amended. So it says that in any criminal or civil cause or matter, the application for judicial review shall be made by notice of motion in a specified schedule. So when you go to the schedule, the notice of motion is here. Now, you people, you have issues. Do you think they are mad to provide for you the notice of motion? You think they are stupid, eh? They don't know how to have your notice of motion. Huh? You think they are stupid? Yeah. You will find someone who is not even aware that we have a different notice of motion. This person says, I know that one. I've been drafting interim injunctions here, bail. You do copy and we shall paste you at the end as well. Okay? So the law is different. You get out of the extra one, I've done judicial review. It is not of motion. Now, we have the same answers, but when it comes to marks, I have a 75, you have a 51. Scales of L, this no. But because for you, you don't pay attention to details, you will feel the pinch. Okay? So now, we presume you have applied, you have drafted your notes of motion, you have filed, you have applied. Then ask yourself, what factors will court consider? Okay? Notes of motion. Okay? Yes. So we presume that you have filed, and upon filing, okay, court is set to determine your matter. Okay? So what factors will court consider in such circumstances? Or what factors should you prove to court in such circumstances? Okay? Which factors will court consider? Counsel, the first one is you go to the judicial review rules amendment. Okay. We go on. What factors are considered? Look at Rule 7 capital A of the amendment. Whatever is stated therein, it should be put into consideration. Okay. 7A. Okay. Rule 7 capital A of the amendment. Okay. You open the amendment, it has capital A. You'll see it. Okay. Okay. So when you look at one, they say you should first determine whether the matter is applicable for judicial review. Then 2, that the aggrieved party has exhausted all existing remedies. What does that mean? They will give you facts. They tell you that once you are, that the rules of administration of LDC, they say if you are aggrieved with your marks, you have to first apply for appeal or you apply for a remark. Now they give you facts where the decision was made, but Rashid has not yet applied for any of the 2, and you take Rashid to court for judicial review. When I come to court, I don't waste time. I'll just raise an objection and I say, my lord, this matter is premature. Before this honorable court, I pray it is dismissed. You get it? So as a result, it is what under 7A, when the rules say that you have what called administrative remedies, first exhaust all of them before you go to court. So when you are reading your fact, ask yourself, this institution that passed the decision, okay, was it having what we call internal means of settling? Did this person apply for them before you rush for judicial? Once you apply for judicial review, okay, and you have not exhausted, it will be dismissed. Yes? Okay. Then, whether it is can need a payment, can be considered. Okay. So, Then lastly, that the matter involves an administrative public body or official. Okay. Now, what if it is a private institution? Can you go for judicial review? Private institution. Can you go for judicial review? Huh? Is Jambo a private institution? It's a government institution. Okay. A public body or official. Okay, so look at such factors. Then, okay, so now you've applied, okay, you've read everything. Your client passes the test, he can. You've known the exact thing you need. Now the question is, what remedies, what orders are you going to seek for? Those ones don't need to debate. Section 30 what? 36 of the Judicature Act settles that matter, read together with section rule 3, okay, of section 36 of the Judicature Act, read together with rule 3 of the Judicature Judicial Review rules. But please, we have circumstances where statutory will not work. We have circumstances where the mandamus will not work. So when you are apportioning these remedies, don't just write. Don't just write. Okay? You have people you can't compare. An example, when you read the case of Dr. Stephen Okello versus Chambogo University, okay? Justice Sekana, because one of the prayers we prayed for in that matter was with Council IK. I was in year 3 by then. I was working with Council Semakade. So one of the prayers we prayed for, because actually those facts look like the facts here. That guy was acting as the acting academic registrar of Chambogo. So when they advertised, the rules are that the acting should be given priority. Now, the guy didn't pass the test. The opportunity was given to someone else. So after passing the decision, first we came in, full body, full blast, no joking. So we went to court. So we told him, hey, okay, so we told him what to maintain the status quo. He had the office padlock. We told him, can't lock the office. He went home and slept. So in the morning, we come to court. The guy is not in office. We prayed for an adjournment. We told him, you can't sit in office. You'll be opening until. Don't sleep in the office. Because once you get out, chances are high, you will not find, they will change the lock. Imagine when the matter is tomorrow, the guy went home to see the wife. He came back when the lock is changed. So we went to court. We had prayed for an reinstatement, yeah, but it is the mandamus. We wanted to compel, okay, Chambogo to exercise the powers that the acting should be given priority, but that it wasn't granted. You know why? Court held that we have circumstances where you can't compel someone where the relationship between the parties is completely done. You can't force parties to stay together. It is an absurdity and an injustice of keeping the applicant in his own prison. Okay? No, it can be enforced, but you should care so much about the environment. That environment is going to be toxic. It's going to be toxic. So don't apply for orders that are going to affect your client at a later stage. Be mindful. Yes, we know. You know the mandamus, you know the prohibit. We have circumstances where the process has come to an end when the facts are clear that there is no any other chance of repeating the same process. Now you go for prohibition. What are you prohibiting? What are you prohibiting? But the most appropriate is what we call circularity, to quash. First quash, then you can make an order that they repeat the entire procedure the way it is supposed to be done the right way. But these two, mandamus and the prohibition, be mindful when you are applying them. You will apply them on facts where they don't apply. You will not hear. Okay? So be mindful of the same. So now you know that your client has the potential, you know everything you want, you know even how to apply. But before you apply, the last question you ask yourself, are we within time? That takes us to the last question, time within which to apply for judicial review. Okay? You may have a fact when you are not within time. Okay? So, which law provides for time? Okay, so when you look at the principal rules, okay, when you look at, okay, rule 5, okay, rule 5, it says that an application for judicial review shall be made promptly and in event within 3 months from the date when the grounds of the application first arose, unless the court considers that there is good reason for extending the period within which to apply. Okay, so that implies that the most appropriate time is within 3. Now you see, LDC is good. Okay, how? You can read this act very well. Okay, however, it has something. They say that listen, that an application for judicial shall be made promptly. Underline the word promptly. They can tell you, they can give you the facts where your client is out of time to apply, and you see it, you see, and you read that the law can provide for room for extension of time. Then they tell you to oppose the application for extension of time. You look for the answer, but it is in the same act how they oppose. What's the meaning of the word promptly? Day and then. Now, why are you extending time? Justice, ladies, justice. Okay, so you look at the, it says the application shall be made promptly. Okay. You get it? And before you look for how to oppose, this is hard. But it will make your life hard. You don't want to understand. Okay? So, now that's what I'm telling you. You make an application for then they pause. That's why I'm referring to the word, this being a matter which is supposed to be dealt with, because when court is determining them, the rules are clear. Within what time to deal with this matter, the trial shouldn't exceed how many months? Yes? The trial shouldn't exceed how many months? Yes? Yes? When you look at Rule 10, hearing of application for judicial review, okay? So when you read Rule 10, it provides for that time. how the time frame within which the application should be determined. So we entertain even the extension of time. Who was let me look for it here. Okay, when you look at the amendment rules, Rule 7b says an application for judicial review shall be disposed of within 90 days. Okay, imagine, okay, it is supposed to be determined within 90. So we entertain the application for extension of time. It is Rule 7b, the judicial review rules amendment. Okay. No, within which once you apply, court has 3 months to determine the matter. So now you mean you can file an application again within those 3 months? Even you're laughing at yourself deep inside. The reason why they are called specialized proceedings, they don't delay. What happens in petitions here? They are called specialized. Don't think of these, they don't want outside. Why should you waste time? So any question on judicial review? Yes? Any question on judicial review? So things are simple. So now, when you read the part 1, is it for judicial review or constitutional interpretation? Okay, now let's go for what we call constitutional matters, constitutional petitions. Let's go for constitutional petitions. Now, but I'm going to explain. We have what constitutional matters are brought in 2 ways. We have by petition and by reference. They'll give you facts where court is determining a particular matter. When the matter is in court already, you get it. Okay? And an issue comes up on interpretation of the law. They first pause, they refer that provision to constitutional court. That's what we call by reference. Okay? When there is a matter, a civil matter or a criminal matter that is ongoing, then court finds a challenge on interpreting a particular provision. So it raises a matter of constitutional interpretation. So by way of reference, the matter will be first referred to constitutional court. That's what we call reference. Then we have circumstances who just bring a constitutional matter straight directly. Those are the 2 ways. Okay? So, yeah, yes. But what they mean that how do matters go to the constitutional court? It's by way of reference or by way of petition. Yes, all courts can refer matters for constitutional interpretation. It can refer back if the matter is for interpretation of the law. Yes. Okay. So we go on. So let's start with our constitution. Okay. We start with our Constitution as amended. Who has ever heard the national objectives of this country? Yes? Who has ever heard the national objectives? Hmm? Okay, so let's go to Article 137. Article 137, it says Constitutional Court. Constitutional Court. So when you are dealing with the constitutional matters, all matters relating to constitutional interpretation should be forwarded to the Constitutional. So that means here we are looking at what we call jurisdictions of constitutional matters. Okay. So when you look at Article 137, which is so emphatic, it says any question as to the interpretation of the Constitution shall be determined by the Court of Appeal, sitting as a constitutional court. Okay. So now that's the first. Okay. So now, who can bring a constitutional petition? Yes, Hajat, who can bring a constitutional petition? The Muslims. Yeah. The Muslims. Yes, who can bring a constitutional petition? Any person, eh? When you look at Article 137, clause 3, it says any person who alleges, underline the word any person. That means anyone can bring a constitutional petition. Okay. So now, under what circumstances do we go for constitutional interpretation? Article 137, clause 3, paragraph A says a person who alleges that an act of parliament or any other law or anything in or done under the authority of any law or an act or omission by any person or authority is inconsistent or in contravention of the provisions of the Constitution. Okay, so here they are saying that where any act of parliament, any action that is done in contravention of the Constitution. So now you may think that it's only the law. They give you a presidential directive, okay, which gives directions to police officers when they find you putting on a wig. Okay, putting on a wig, they cane you. Okay, it's a presidential, but the actions, are they constitutional or unconstitutional? So is that directive inconsistent to the Constitution or not? Okay, so you take that for constitutional interpretation. Sometimes she might be occupying a particular position. For her, she says that according to us, she does an act which is inconsistent to the constitution. Okay, so as a result of that, you go for what we call constitutional interpretation. So I did it. Okay, so now after reading the constitution, then we go for what we call constitutional. You see, what you do, you read up to the end of that article. It's the only thing that provides for constitutional. Okay. Yes, Council.
When you are playing constitutional court, the fact is about high court, proceed under get to look at the action of the taken by the police. Together with approach, it's a bit confusing.
No, she proceeded under wrong law. That's why the Constitutional Court, after giving you the right interpretation, they can refer the matter back with recommendations. Okay? Okay? So let's go to what we call the constitutional. So under this, yes. 137. Yes. That very provision, even mere actions can be unconstitutional. Okay, so it can be an act of parliament or a mere action or omission. Okay, yes, let's go. Okay, so when you look at we go. So we said that matters are brought by two ways. Okay, we have by a petition and by reference. So ask yourself, how do we move if it is a petition, and how do we move by reference? The rules are clear. The Constitutional Court, petitions, and reference. That means you either go by a petition or by the require reference. How do you tell your sons and daughters?
But you don't work.
Okay. Well, these things are very simple. Okay. So when you look at okay, so we want to understand, we are still dealing with basically what we call petition. We've not yet crossed to reference. You get it, yeah? So let's go with petition. When you go to Rule 3, it provides for forum and contents of the petition. So that means please don't draft petition in family. Get the rules, open it. The petition is there. Don't rush. Okay? The petition is there. And the reference is also there. Petition reference. Okay? The petition is there and the reference. Don't draft something you don't know. Okay? Simple as that. Okay? Form 1 is the petition. We are dealing with a petition now. Okay? So don't rush. Now, the question we need to ask, do we have time frame? Okay? Constitutional reference, constitutional petition reference rules. The question is, okay, do we have the time frame within which we bring the petition? Yes? Do you have a time frame? Yes? Yes? Under which law? Do we have matters that don't have a limitation? I ever thought of it? Huh? Yes? So, when you look at our petition, okay, its contents are very clear. We've seen where they are. So now, you've understood your client can bring a petition. Then 2, you've understood that it's a petition, but not a reference. Okay? You know the contents of the petition, but then ask yourself, can I bring this petition or not? So that takes us to we are still dealing with a petition. It's where the matter is not in court. Okay? An example, who read the case which was challenging the Computer Misuse Act? You read that case? Okay. That act was challenged that it was unconstitutional. Okay. When you look at the case of Susan Chigula versus AG, that constitutional petition, that matter was ongoing in court. You get it? Okay. When she challenged the constitutionality of a death sentence, her matter was in court, but it was concluded. Then after her conviction, she lodged an appeal, okay, and then also went for constitutional interpretation. Okay? Petition. Yes? Where reference, okay. We are not yet. I was going to give you after reading the provisions. We've read on the provision for petition. Then after, we are going to read the provision for reference. At the end, you will be able to tell that this is for petition, this is for reference. Okay, petition, the matter is not in court. You just wake up, you say, I'm challenging the penal code. Okay, you get it. You wake up, you say, I'm challenging the penal code. You go to court. When you read the case of also Uganda Women Lawyers Association versus AG, when they were challenging the Divorce Act, it is by way of a petition. The matter was not ongoing, just there and then, full blast. Okay? That one is a petition. Okay? You shall get there. Okay? So, are we to get, let's look at time. Let's look at time. Okay? Let's look at time. Okay? Let's look at time. When can we present the petition? Yes. When do we present the petition? Anytime you feel like. Answer. We have the rules there with you. Yes. Yes.
The petitioner shall lodge
Procedural provides for time within which to bring a petition. Which rule? Which rule? Okay. What you should understand that matters of great public importance, they have no limitation. Okay. We have, for example, constitutional matters and then human rights. They don't have limitation because they are of great public importance. Limitation is on individual matters. Mark that. Constitutional matters are great public litigation. We don't have limitation even on human rights enforcement. That's why. But you look at all the rights when you are in court, they are non-derogable only. However, since someone challenging a right to education, when they don't give you fees, you don't even feel like throwing a party. Yes. Yeah. So what do you expect? Okay. So let's go on. Then let's go by reference. We go back to the Constitution now. Okay. When you look at good time. Okay. When you look at Article 137, Clause 5. Okay. Listen. Clause 5. It says, where any question as interpretation of this Constitution arises in any proceedings. Now you get the difference. That's what called reference. Where any matter of interpretation of this Constitution arises in any proceedings in the courts of law other than the field court martial, the court may, if it is of the opinion that the question involves substantial question of law, and shall, if at any proceedings, request it to do so, refer the matter to the Constitutional Court. That's what, so reference, the matter should be ongoing in courts, and the question of interpretation comes into play. Very simple as that. Okay, that's how we go. Okay. It's Article 237, Clause 5. 137, Clause 5. Okay. Then after we go to Rule 18. Rule 18 of the Constitutional Petition and Reference Rules. It says manner of making a reference to court. Okay. So what if they tell you to draft a reference?
We have it.
Oh, yeah, good. Okay. So the contents of a reference, they are under the second schedule of the rules. Okay. Form 2. Okay. Okay. Rule 18. So now, at least make sure you've read the following cases, at least for constitutional interpretation. There is the one I know you can't read. That one I can even bet. Okay? You can read, it's small. You can't read the case of Elias Lukwago and the others versus AG. What you call Tojikwatako, they were consolidated, where they were challenging the Tajikwa case has 500 plus pages. I read it for 4 months. I read it. 400. Sit down, guy. You scroll and it has a lot. It has good arguments. You want to keep on flowing, yeah? At in posing and next you wanna come out. Okay, but at least read the case of Uganda Women Lawyers Association versus AG. You read the case of David Sejusa versus AG. You read Susan Chibula. Those common constitutional interpretation matters. Okay, we have a recent one. We have Bob Kasango versus AG. Okay, yeah, that talked about appointment of the chairperson of the Electoral Commission, and the AG was challenging their constitutionality. Okay, those are good constitutional matters. We have a recent one. Okay, we have the recent one that has challenged which act? The Narcotic Drugs Act. Yes, but the decision is there. Yeah, you look for it. Okay, you read. No, they will overturn. Okay, so look at such cases. They are good. They are good. Okay. When you read it, says where a reference to court regarding a question of interpretation under that article, it shall be made. It shall be made. The original court shall submit the reference in terms in form 2. Has no supporting document, just the form is sufficient. Okay. So now we've seen so far 2 topics. Okay. So we have another topic known as enforcement of human rights. Enforcement of human rights. Okay, we have enforcement of human rights. So now, when you are dealing with human rights, what are you supposed to know first? 1, types of human rights. They are 2. They are 2. We have what we call fundamental human rights and non-derogable human rights. So when you are enforcing a right, understand, because when we are dealing with the enforcement of human rights, jurisdictions differ. When you are enforcing non-derogable, we go somewhere different. And when you are enforcing these fundamental ones, we go somewhere different. So before you start doing anything, ask yourself, the human rights I am dealing with, they follow under what provision? Okay. Are we together? So now, we can't read human rights into Zimalayo. We can't. Everything is a right. Okay? But what are we supposed to look for when we are dealing with human rights? 1. Okay? Counsel Aisha, what's the cause of action in enforcement of human rights? 10,000. 10,000. Who has given you authority to answer? Who has given you authority to answer? Okay, so let's go on. Okay, so now when we are reading, first understand which law gives you a right to do enforcement. We all enjoy rights, because if we say we are to read human rights, the entire constitution almost we have to read it. Okay, the way you people shout rule of law, rule of law. Where is rule of law? Non-derogable. These are rights that do not extinguish at whatever cost. But fundamental rights, they can be extinguished where we are in what we call that circumstance where all laws don't operate. How do you call it? Yes, where they declare a state of emergency. But under that, the non-derogable, they don't cease. Okay, a right to fair hearing does not cease. Okay, we are going to see them. Let's go. Okay, so now when you are dealing with human rights, first things first. Okay, let us differentiate between fundamental and, but what we are interested in, what we call the non-derogable rights. These are provided for under which article? Yes, we've said when we are enforcing, we first understand whether they are non-derogable or fundamental. So the fundamentals for not to man, but we are interested in the non-derogable human rights. Okay. So when you look at Article 44, it says, notwithstanding anything in this constitution, there shall be no derogation from enjoyment of the following rights and freedoms. Notwithstanding anything, that even if we declare a state of emergency, these ones will remain. Article 44. 1. Freedom from torture, cruel, and inhuman, degrading treatment. Okay, Article 44. Then 2, freedom from slavery and servitude, right to fair hearing, right to an order of habeas. Those ones here. Okay. Then the rest are known as fundamental human. The word fundamental means just something you. Okay. Hey, Sovoka. Yes. Yes. Yes, Council. Those ones, they are in addition to the fundamental. Yes. For example, right to food, right to education, right to association, right to access. Certain words we use. We have in constitutional law at undergrad. They would set a question and they say that the rights under Article 44 are absolute. Discuss. Okay, but something absolute, it is not questionable. So whenever they say that all human rights are absolute, the question is, can those human rights be limited at a particular time? Look at the right to association. It is limited under what circumstances? Okay. Look at the right to access information. YouTube, actually, Facebook is illegal in Uganda. Yes. That's why I use VPN. Isn't that a right to access information? It can be limited under what circumstances? State of security. Okay. A right to movement. We can stop you. Okay. So, but when it comes to how can you start to torture me, the son of my father? My father. Hey.
The husband of your wife.
We. Yeah. Shia. This is our government. Okay. We proceed. Okay. So you get it. So now, after looking at those, ask yourself which law gives you the right to go to enforce your rights. Okay. Then you go to Article 50. Okay. Article 50, which says that enforcement of human rights. Any person who claims that the fundamental or other of freedom granted under the Constitution has been infringed, threatened, is entitled to apply to competent court for redress. What does that mean? Okay, they have told you fundamental and or other rights to a court of, whenever they say a court of competent jurisdictions, that means there is a questioning back on the right court to go to. Always mark that. Okay. So now we presume that there has been a violation of human rights. The client is before you, they have given you a dialogue like the one you have in your facts. The question is, who can bring an action for enforcement of human rights? Who can bring it? Yes? Who can bring it? Any person. Okay. Any person aggrieved. Okay. So we have what we call the enforcement of human, or the Human Rights Enforcement Act and its rules. Okay. So they will tell us how to deal with this. Okay. We have what we call Enforcement of Human Rights Act and the rules. Okay. Now, I told you, whenever you are reading any act, before you do anything, first read its applicability. Every act that has applicability, there is a reason why they have given it to you. Okay? You get it? Okay? So let's start with section 1. It says this act applies to enforcement of human rights and freedoms granted by chapter 4 of the Constitution. This act shall apply to the enforcement of rights by competent court. Save as provided in this act, the act shall not apply to investigations, protections, or enforcement of rights and freedoms of Uganda Human Rights Commission and Equal Opportunities Commission. So what does that mean? We have rights that are enforced by, so where you have a matter which is under Human Rights Commission, does not apply to this act. So you get it? That's the starting point. You will go for the matter which is not supposed to be under this act. You rush and bring it here. Okay? So now, when you look at this, it takes us to what we call enforcement of human rights. Where do we go? The first one, where we go, is what we call the Human Rights Commission. Okay? It is established under which law? Well, it's established under the Constitution. It's a feature of the Constitution. Okay? So when you look at Article 51, it establishes the same. Okay? It establishes the same. Then when you go to Article 52, it gives you the functions, okay, of this entity. Yes? Yeah. Wait out. Ask yourself which rights. That's what we've been addressing. Are those matters handled by the commission? You get it? Okay? You get it? Let me give you an example. You saw some people when they went to raise a complaint. Was that complaint handled by the commission? The matter had to be referred to courts. Why? Fundamental human rights are enforceable by courts. Other rights, the non-derogable ones, are by courts. Okay, that is it. Then after, you got what we call the Human Rights Commission Act. Okay, then I help you like here. Okay, we don't have the Human Rights Commissions Act. Okay, we don't have it, but we look at it, it will tell you the matters that are handled by the commission. It's in the act. Okay, so now, because when you look at section 1, subsection 3 of the Human Rights Enforcement Act, it is very clear, save as provided. This act shall not apply to investigation, protection, or enforcement of rights and freedoms by the Uganda Human Rights. So where the matter is handled by the commission does not follow under this act. Okay? Applicability, mark that. Okay? We've said section 1, subsection 3 has some matters that it excludes from being applicable or enforced by the act. So you first iron out those matters before you proceed. Okay? Are we together? Okay. We proceed. Where did you go? Yeah, here. Okay. Let's go to section 3. Okay. Okay. So let's first, okay, let's first deal with this. Okay. When you look at so we want to understand who can bring an action. Okay, we go to section 3. Okay, yes, section 3, subsection 2 of the Human Rights Enforcement Act. The one, okay, a person acting on behalf of another who cannot act in their own name. But if someone was killed, okay, can I enforce on behalf of someone? Okay. Then a person acting as a member or in interest of a group or class of persons. You can say, let me sue on behalf of my fellow students, I sue LDC. Okay, because they are violating rights. I'm just giving you an example. Okay, you get it? Okay, for example, you've seen my for him, he doesn't fear danger. To play with, he sued his dead father for an order of DNA. granted, they told him to go for exhumation, and he feared. They gave him an order, let him exhume the dead. They make the DNA. Okay, but it can't come out. But you look at the time, because the act provides the time when you can do exhumation, and you make the order. The DNA, the Children's Act tells that order. We'll go on. Okay, so now. Okay, then members, let's come back. A person acting in public interest. Now, mark this. When you look at the first category, a person acting as a member. Okay, we are here. We have a group. So for you to come out because you are a member in our group, you sue for enforcement of our rights. Then we have a person acting in public interest. Okay, this person has no attachment with you. Okay, but for him, he says, I need to see Ugandans need to have a look at someone is driving permits. Okay, he makes an application on behalf of Ugandans. Okay, so you get it. So this person, you're not connected in any way, but for him, he says, let me go for it. Okay. No. Yes. Another category, okay. Another category, we have an association. Okay. We have an association. For example, we have FIDA. We have Uganda Women Lawyers Association. We have Legal Brain Trust. We have SEHAD. All those institutions, the human rights enforcement standards on behalf of an individual. Yes? It has ever brought a matter on your behalf, on behalf of lawyers. Counsel, that is your independent idea. I associate my submission with your
When you look at the business, around 20,000, compared to last year.
Okay, now let's go to, we've seen someone, okay, who can bring this matter, not so. Then let's go to jurisdictions. Members, let's get back. We're out of time, eh? Let's go to jurisdictions, okay? Now, when it comes to jurisdictions, please take your time and understand. Jurisdictions have rights that are enforceable by the High Court and rights that are enforceable by the Magistrates Court. They'll give you facts. You file the matter in the High Court. Automatically, jurisdiction is a breach of the statute. Section 4, enforcement of rights and freedoms by the High Court. Okay. It says, the High Court shall hear and determine any application relating to the enforcement or violation of non-derogable rights under Article 44. Once you see you have torture, High Court automatically. when you read the case, okay, made that Remedies and who else? Maiga Peter versus AG. It was an application of Fabius. It was in the High Court of Uganda. Okay. Rights and freedoms restricted under the law made for purposes of state of emergency. Laws that don't extinguish where we are under the state of emergency. Okay. Then rights and freedoms determined by the magistrate court where the remedy sought is beyond its pecuniary jurisdictions. Okay. Bakubienyo, there's the damages you've incurred of 1 billion. Okay. You only go to the high court. When the damages you are seeking are beyond, you just go to the high court. Okay, so if the man can't do very well, and you see that, okay, then we have also rights under section 45. So when you are reading your facts, ask yourself, the facts I have fall under what category before you draft your pleadings? 45. Okay. 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 Then when you go to section 5, okay, it provides for enforcement by the magistrate's court. It says 5. The magistrate court shall hear and determine applications relating to enforcement and violation of rights and freedoms in chapter 4 of the Constitution or in any other circumstances not referred to in subsection 1 of section 4. So what does that mean? That the rest, apart from under Article 44 and 45 and the state of emergency, the rest are by the chief magistrates. Right of education, right to marry, right to conjugal rights. Okay. Yes, if you see that the rights are in your facts are not under 44, are not under 45, are not under the state of emergency, all the damages the client is seeking for are within the jurisdictions of the magistrate's court, kindly smartly work with the magistrate's court. So when you look at your facts, put all of those factors in consideration. So now, how do we apply for enforcement? Is it by notes of motion, by chamber summons, by complaint on oath, or? Yes? How do we apply? Yes? How do we apply? When you look at Regulation 3 of the Human Rights Enforcement Procedure Rules, the application is by every application shall be made by motion and shall be heard in open court by a single judge of the High Court. Yes, so that means applications are by, not so motion. Okay. Yes. Okay. Then so now you should proceed also and look at the amendment of 2019, the rules amendment. They just go, they are so emphatic on who can bring the action. They go on giving you the circumstances under which you can go by public interest. They expound more on what we have looked at. Okay. And mark this, the notice of motion is in Schedule 1. Okay. The notice of motion for enforcement of human rights. Don't draft your notice of motion. Okay. is in form 1. Okay. Yes, it is also by motion. So now, those are the laws we had to look for, but for purposes of emphasis, we may not read these facts. We read them. Part A of workshop 2 has 2 remedies therein. It has 1, enforcement of what? And constitutional interpretation. Okay. It has enforcement of human rights and are you sure? Are you sure? You trust me? Huh? You trust me? Huh? Okay, so let's look at, we are not going to them in conclusion that this is this. So A, the facts of A, the things you underline, okay, says that before you is Mr. Geoffrey. He is unhappy with what he is going through. He is seeking your legal advice. 1, he was employed as a human resource and administration manager of Uganda Human Rights Commission. Stop there. Uganda Human Rights, is it a private body, public body? You underline in all the remedies you've been looking at. What remedy talks about public bodies? Judicial. He says that, however, on the 2nd day of June 2023, he received a termination letter from Uganda Human Rights Commission. That means a decision was, that means he is aggrieved with that. So ask yourself, what is the procedure they used to reach at this decision, or what happened after this decision? Okay, because after taking the decision, this guy refused to come. No, because the letter was telling him that his contract has been. Then because he didn't appear, he was called for absenteeism without lawful orders. He was charged. Now, which is who? Now you're telling me I've absconded without lawful orders. So should I cut myself into one place to stay home? Actually, after 40 what? Okay, Article 42 is clear. Every person deserves to be treated justly, and so is that just unfair? So that means the parts of Part A have what we call judicial and what? Okay, when you proceed with these facts, so Part A, we are going for judicial. Then Part B, we are going for Part B, we are going for what? Part B, we are going for. Look at how did these guys come to the conclusion? Yes, it was pursuant to the cabinet directive to cancel all the titles in the Kingfisher Discovery area in order to render vacant possession to give ownership to Sinaco. Where is the problem? Yes? Where is the problem? Yes? Where is the problem? Okay? They use the presidential directive. Yes? Okay, listen. Prior to being registered as a proprietor of land, formerly comprised in freehold register that he had occupied the same as a customary tenant and cultivated. Close to year 26, he embarked on the process of registering his interests. He continued to occupy and quietly enjoy possession of the land together with my tenants, including among Mugisa Robert and whatever the case may be, who recognized him as the registered proprietor and owner of the land until 2012, when Sinop Uganda Limited approached him and offered to take over part of his land for purchase of construction of road, for purposes of construction of road to serve the oil exploration activities. Mr. Eli Akiza tells you that he was approached by Sinop Uganda Limited, who sought to construct. Now, when you look at the process of compulsory land acquisition, okay, so Sinop is a government entity, not so. It was to compulsorily acquire his land. Okay, so what happened? They are telling that Sinop Limited, however, at the last minute and after the final survey and evaluation of the chief government valuer, stated that had been approved on the agreement of the pretext that there were disputes related to the land, and as such had instructions not to pay compensation where there were disputes. So the question is, okay, can a presidential directive override an act of parliament? So there, because there was a presidential directive. Remember, Article 26 says that every person has a right to own property. No person shall be compulsorily deprived of without. This guy was the rightful owner, not so. You get it? So now, these guys took over land basing on a presidential directive. So, can a presidential directive override the provision of the Constitution? So, part B goes for what we call constitutional. Is it by reference or is by a petition? You see, these things are simple. Huh? Then the last part goes for what? Yes? The last part goes for enforcement of human. What orders are they interested in? What are they questioning, council? What are they questioning? Huh? I told you on enforcement, please go slow. On enforcement, we need an order of habeas. Okay? Yes. It can happen. I'm getting how. For example, when you look at that case of Numbers, it was enforced, but these guys were nowhere to be seen. We wanted to know where they are. Okay? But other circumstances, we may go for what we call compensation and damages. So when you read your facts, these guys were tortured. And the torture falls under Article 40, 44. They were treated inhumanly, degrading treatment. They were tortured up to death, some of them. Yes. So that means they are going for what? Enforcement of human rights. To which court? High Court. Yes.
Council.
Yes.
Hello.
Yes, Council.
Council, on B, you said what is the remedy?
On B, we are going for constitutional interpretation, Council.
But now, actually, okay, but when she was doing what the introduction on I think last week, she talked about someone having land, and like, of course, she talked about the Article 26, as you said, but she said she was saying that instead, because most cases sometimes people go for a plaint and do such stuff, but she said you can just go and you can just go and do you enforce this right to own property, and then you get a remedy. So I thought we can
now
also...
now Council, okay. Okay, you can discuss two things on that. Okay, why his right to own property was infringed on, you can proceed under that line. But however, because the commissioner and registration for him is saying that he has a presidential directive, okay, that's why this title was cancelled, and then the guy was not compensated, because the government does not cancel titles just like that. You get it? So you can discuss the two positions, Council, just for enrichment of yourself. Yeah. So let us call it a day, inshallah. We shall meet tomorrow for question interpretation. But mark this, you don't have classes on Friday. The IA is on Thursday. You know what to do. Okay.